A very warm welcome to all of you present here on behalf of Enfold Proactive Health Trust. We thank you for joining us for this webinar on advocating for children in conflict with law, engaging with the social investigation report. Before we get started, a few housekeeping rules to ensure that we have a meaningful and engaging discussion together. During the session, we request all participants to keep your microphone on mute and your videos off. After the panel discussion, we will be opening up the forum for discussion, questions, and comments. At this time, you may raise your hand and we will call you to unmute and ask questions. Please feel free to use the chat box to put up questions. Our team will draw the attention of the panelists to the questions in the chat box during the discussion session. Please be respectful and constructive in the chat and during discussions. Lastly, do note that we will be recording the webinar. Enfold runs the Child Rights and Access to Justice Fellowship with a cohort of 24 lawyers from 4 states, Karnataka, Madhya Pradesh, Uttarakhand, and Tamil Nadu. These lawyers represent children in conflict with law at the JJBs, children's courts, and high courts in 10 districts. Effective legal representation for children in conflict with law requires looking beyond the case details to address their psychosocial needs. The Social Investigation Report, SIR, is essential to this process, providing a holistic view of a child's circumstances, from family background to support systems. Today, we aim to examine the critical role of the SIR and psychosocial support in shaping informed, child-centered lawyering and judicial outcomes. I am pleased to introduce the panelists, Kshipra Marathe, Amaidhi Devaraj, and Advocate Geeta Sajjanshetty. Arlene Manoharan will moderate this session. Kshipra Marathe is a psychologist and practitioner working with children and youth at risk. She holds a master's degree in forensic psychology and brings over 6 years of experience working with children in conflict with the law. As program manager at Ashiyana Foundation, she leads work on the rehabilitation and reintegration of youth transitioning out of institutional care, supporting their journey back into society with care and continuity. She is also a trained restorative justice circle facilitator, having undergone formal training in restorative justice practices, and brings this lens to her work with young people navigating the juvenile justice system. Amaidhi Devaraj is a human rights lawyer by education and has over 18 years of experience in child protection, education, health, and social development sectors. She has held diverse leadership roles, including head of human resources, operations head, director, and mentor in both national and international organizations. She currently leads the Access to Justice for Children in the Juvenile Justice System project at the National Law School of India University, NLSIU. The project has a team of lawyers, social workers, and researchers dedicated to providing legal and psychosocial services for children in conflict with the law by means of a help desk established at the Government Observation Home, Madiwala, Bangalore. The project aims to strengthen the juvenile justice system by building capacities of the stakeholders in the system and through research and advocacy efforts. Amaidhi has always been passionate about social change, and she actively seeks out opportunities in both her personal and professional life to contribute towards the holistic development of society. Ms. Geeta Sajjanshetty is a practicing advocate based in Kalaburagi with extensive experience in labor law, HIV/AIDS rights, and child protection laws. She has worked with the Lawyers Collective and the Center for Child and the Law, NLSIU, where she had the opportunity to represent children in conflict with the law before the Juvenile Justice Board, Bengaluru. This experience provided her with a deeper understanding of the nuances of the Juvenile Justice Act and transformed her approach to legal representation in juvenile matters, moving beyond the traditional role of an advocate towards a more child-centered and rehabilitative perspective. She has also served as a member of the Juvenile Justice Board at Kalaburagi. Arlene Manoharan is a trained social worker with specialization in child protection, a safeguarding expert, mediator, and restorative justice practitioner with 36 years of work experience. She holds a master's in social work from the Tata Institute of Social Sciences, Mumbai. She worked directly with children in street situations as well as within the juvenile justice system and with children alleged to be in conflict with law in the observation home at Bangalore. She initially worked at various NGOs in Mumbai and Bangalore and then at the Center for Child and the Law in LSIU, heading the multidisciplinary juvenile justice program where she engaged in socio-legal research to inform and reform policy, law and the child protection system. Conduct training of juvenile justice boards and child welfare committees, teach on child protection and author a range of publications and even led the center itself for 2 years. She also conceptualized the CCL NLSIU Handbook for Advocates working with CICLs and was a member of the NALSA committee for drafting this and contributed to the modules as an author or co-author. She was appointed to various statutory committees under the JJ Act, such as the Selection Committee, the Karnataka JJ Act Rules Drafting Committee, the National Committee to Review Amendments to the JJ Act constituted by the Ministry of Women and Child Development, Government of India in 2011, and the Working Group on Child Rights constituted by the Planning Commission also in 2011. She is currently working as the co-director of the Restorative Practices Program at Enfold. I will now hand it over to Arlene. Thank you, Arlene.
Thank you so much, Anne. Again, a very warm welcome to our very experienced panelists. I'm very excited today for this conversation that we're going to have. This is especially because the Juvenile Justice Care and Protection of Children Act, both in 2000 and in 2015, stands apart from many other laws, not only in India, but across the world. As in my view, it embeds an interdisciplinary approach into the very structure of the bodies and the systems that are designed to enable justice to children. And that is the structure of the Juvenile Justice Board, etc. It recognizes that decisions affecting children require not only effective legal expertise, but also a deep understanding of child development, psychosocial needs, family dynamics, and what rehabilitation would mean for children, especially many of whom in our country who hail from living in street situations. Our juvenile justice system therefore recognizes that justice for children requires more than legal processes. It requires child-centered, rights-based, trauma-informed approach that understands each child's developmental needs and lived experiences. And the role of counselors, probation officers, and lawyers are all extremely important, enabling the fulfillment of the objects of the Act, in which we are all familiar with, aiming towards justice, care, protection, treatment, development, rehabilitation, and social reintegration. And today we are very experienced panelists who together we will explore how multidisciplinary collaboration can ensure that children are not only legally represented effectively, but also heard, understood, supported, and empowered throughout their journey through the justice system. So let's listen with curiosity and understand how we can collectively strengthen the juvenile justice system and effective lawyering so that it advances rights and upholds accountability while also promoting rehabilitation, dignity, and hope for every child in conflict with law. I begin with Kshipra, the mental health practitioner on the panel. Kshipra, I have a few questions for you, and maybe the first one is, could you tell us that in your experience, what are some of the most significant factors that contribute to a child's conflict with law, and why it is important for lawyers and JJBs to understand these factors?
Yes. Hello, am I audible? Yes. Okay, perfect. So I think in my experience, like you rightly said, Arlene, there are multiple factors often interlinked to each other that lead to a child coming in conflict with the law. I think one of the most important factors starts at the family. What all of us have seen who have worked with these children is that the family dynamics play into the child coming into the conflict with the law. If the family is not a safe space, if there's discord in the family, if there's violence, abuse in the family, then obviously that leads to the child experiencing trauma at home, but also that leads to normalization of violence and harm as well. So it starts right at the families, what we've seen. Families who are unfortunately not equipped to look at children who require special attention and care also lead to a child coming in conflict with the law. Also, after family, the another factor is the environment in which the children grow up. All of us have seen that most of these children are also, like you said, from the streets, from backgrounds which is rooted in poverty, also from areas where violence is normalized, addiction, substance use is vastly accessible and normalized. So what that leads to is normalization of substance use, normalization of violence, normalization of gang culture as well, that what we have seen in Mumbai as well. So when all of that is happening, that creates normalization. At the same time, it also leads to impact on their neurodevelopment. So environment is a second factor which leads, and what we are saying is that it is a prolonged exposure. It's not one or two instances that we're talking about. It's as the child is growing up, they're getting exposed to these things constantly, with not having opportunities to get out of those circumstances as well. So this exposure is really one of the main factors. What research also says, and we have read up about this, and all of us who practice in this um, around this act also know this, that the prefrontal cortex of the brain is not developed till the early 20s. And if there is any developmental delay due to trauma, poverty, loss, neglect, the development is further delayed. And what I mean by development of prefrontal cortex is the part of the brain that is responsible for decision making, planning of the future, having any foresight into the future, which a lot of young people lack and children lack, which is and it is because of these factors that it's impacting that development. So it's a very real biological and neurological reason behind children also coming into conflict with the law. And when we are saying all of these factors, and there are multiple, and each case will give you stories and stories of why a child can come into conflict with the law. Why this is important for juvenile justice boards and advocates who are working with children is because there are multiple factors and they are interlinked to each other, and it's not like one after another. It's always very complex. Because of this, we cannot look at the offense as an isolated incident. It's not one off incident that has happened in the child's life where child has caused harm to somebody else or alleged we have caused harm to somebody else. It's these instances one after the another that lead to it. And when you're looking at a child, then you cannot just look at that offense as an isolated incident. You have to look at the story that has gotten them here. And if we don't look at the story, then the spirit of the act is rehabilitative. So if you are not looking at the story behind why a child has come into the conflict with the law, or why a child has ended up in the system, then the child, it's very high possibility that the child is going to go back into the same risk factors as well. So unless and until we get to the story, we understand what are the risk factors that led the child here, it will not be possible to work on these factors. And when I'm talking about these factors which are um, negatively impacting the child, there are also a lot of factors that positively impact the child. So when we are saying that we want to rehabilitate a child, if we don't look at what are the positive factors, what are the potentials that the child has, what are the qualities that the child has that need to be nurtured, that need to be supported with, if we don't look at these factors as well, especially in the juvenile justice boards when decisions are made about the child's life, I think it's very important to look at these factors so that rehabilitation is possible and the true spirit of the act can be upheld.
You're mute.
Arlene,
Arlene,
you're on
you're on.
mute.
Thank you. I so resonate with what you said, and it's so important for us, those of us working with the children, to really understand who is this child, what is their story, what is their life about, and not focus only on the offense that the child may allegedly have committed. Let me ask you, as a counselor working so closely with this group of children, many lawyers and even juvenile justice boards do focus primarily on the alleged offense. So what do they risk missing if they do not also engage with the child's psychosocial circumstances?
I think what they risk on missing is the child's actual needs and vulnerabilities, right? I think we have always said in different contexts that a child in conflict with the law, a lot of times, is a child in need of care and protection. And at some point, maybe did not receive that need of care and protection and has then ended up in the as a conflict with the law. So it's so important to, and then what we're missing out is the needs, the vulnerabilities of the child, the risk and the protective factors, like I said. And then because we're missing out on all of that, the rehabilitation is not happening the way ideally it's supposed to happen, is what the spirit of the act, like I said, is. And I think because we are missing out on this, what also can happen is then the child can come back into the system again. Because if they're released on bail in the same situation, in the same factors, it's very likely that those factors are going to lead them back into the system. And what we have unfortunately also seen that the risk increases. As the child is once institutionalized or once come into the juvenile justice system, then they are targeted by the police a lot more. There is additional stigma that they experience once they go back into the society. So that leads to further risk taking behavior, that leads to further harm that they might experience, and then as a result of that cause as well. So I think this is what we are really missing when we're not looking at these factors.
Absolutely, Kshipra. And I think some of us are aware of this concept called the revolving door, where children keep coming into the system and then getting released either on bail or after their final orders if they are being institutionalized. And then because they're the structural root causes of why they've been in such difficult, challenging situations where they've been had to fight for survival, if those needs are not met, that this child comes back through that revolving door. And what I'm hearing from you, and we've seen in our experience too, that in some cases, not all, that these children also get into an escalator where they're getting from petty crime into perhaps a more serious crime. And that's really where the challenge is, where we really need to come together to try and prevent that from happening. So, Kshipra, can you tell us a story, or maybe an example of some interventions you and the team at Ashiyana perhaps have dealt with a child, and where understanding the child's personal history significantly changed the way the case was understood or addressed, either by the lawyers or by the Juvenile Justice Board?
Yes, absolutely. So because you spoke of revolving door, I have a case where this young boy, he kept coming back into petty offenses. So he would do theft or robbery, but he would keep coming back into the system. Every few months, he was back into the system, and that really alarmed everyone, including us, that what are we missing? That he keeps coming back, and it was every few months that he was coming back. So when we sat with him to really understand the story, we realized that he was abandoned by both his parents. He had never met his father. Very early on in his life, he was abandoned by his mother, and he was brought up by his maternal grandmother, who um, there was a connection with the grandmother, but the grandmother was not equipped to look after a young, growing child. She could not really, there was no parenting, there was no supervision by the grandmother. She was also somebody who was earning for the family. So she was not at home during the day. So nobody was supervising where the child was going, what the child was doing. Because the fact that the child was abandoned by both his parents kept coming into the conversations by different family members, that was impacting the child. That had become the child's internal voice that maybe I'm not wanted and liked. And that led to trauma and further impact on the child's development. What happened as a result of that, that the child would leave the grandmother's house and would live on the streets with his friends. And that's when he started, for his survival, for money, because of peer influence, then started getting into theft and robbery. And that became a cycle that he could not come out of. So when we sat with him, with the Juvenile Justice Board members, because they were quite sensitive and they understood that there was a story that needed to be heard. When we spoke to him, we realized that this is clearly a child in need of care and protection. This is not a child who we can just keep releasing on bail or at the disposal level, but what he requires is requires a stable environment. There were psychological issues that we were assuming would probably need psychiatric intervention as well. And in such a volatile environment where the child is not staying in one place for longer, you cannot provide psychiatric support as well. And when there is no adult supervising, no adult supporting the child's progress, no mental health support is also going to work. The child kept saying he wants to continue his education, but did not have the means to continue the education or the stability to get back into the school system as well. So the last time that he had come into the system, he was in the observation home, and what the Juvenile Justice Board did was that they referred him to the Child Welfare Committee, and then he was declared a child in need of care and protection. And now he's in a childcare institution where he is receiving the support that he really needed. He has that stability that he did not get for the first 16, 17 years of his life. He's getting the support that he needed. He's also on psychiatric care, which was really essential for a child like him. And there's a team of people working with him to ensure that he requires, like, he gets the support that he requires, and then he continues to progress. So this is one example where you really look at what is the need, why the child is coming back. I think just sitting with that and deconstructing that almost is, I think, very important. I have one more very quick story that I want to share of how positive, just like I spoke of protective factors and positives as well. So we had a young boy in the observation home who was a very good singer. Absolutely beautiful voice, loved singing, and he had come in a heinous case. And there were times when he was referred by his case as well. So everybody would call him by the section that he had come in, and he was quite okay with that, having that image of I have done something and I've come. And when everybody realized that he sings beautifully, that that was one thing that everybody started appreciating him on, us, all the staff members of the observation home and the juvenile justice board. And we really kept going back to the board saying, like, have you heard him sing? He sings beautifully. He needs support with the singing. So what we could arrange in the observation home through help of a lot of different people who work in the observation home is get him online classes for singing. So he started singing. Then what we could also manage with the JJB support is arrange a program. So inside the JJB, there was a program, like a 2 hour concert where he sang for all of us, and just the way that boosted his confidence, and seeing everybody come together and look at that boy in a different light. Because what happens is with children especially and young adults, what they hear becomes their internal voice and identity. So I think it's up to all of us as the adults who are working with them to really change that. And with this boy, and because JJB is the authority, so when somebody like JJB also supports this, also echoes what we are saying about the children, I think that really makes a huge difference. So yeah.
Wonderful. So I see that with your intervention and the, enabling the focus on the whole child rather than the fence and the label and the stigma on this child, attitudes changed even within this observation home. And there were also orders that were passed. Do you think that it impacted the orders or impacted the way the lawyer represented the child? Yeah, yeah, wow. That's really something, and I think that's really making the difference. So, in terms of this, and I think this is also part of the psychosocial interventions that you all are doing. Why is this important for the rehabilitation, well-being, and fair treatment of children in conflict with law? A little quickly, Kshipra, we have just about four minutes.
Yes,
Yeah,
sorry.
and
So
I do have some more questions for you. Yeah.
sorry. So we spoke of the trauma and difficult circumstances that get the children in the observation home or in the juvenile justice system. What we also see that once they enter the system, that is equally traumatizing. Just being apprehended by the police, being produced in front of the JJB, though we say that it's a child-friendly environment, it's not really for a child to experience something like this, right? So even if there is trauma in the past or not, just being part of the juvenile justice system, being coming into the juvenile justice system is traumatizing for the child. So I think that's why for stabilization, that psychosocial support is absolutely essential in the first step. I think then when we look at other aspects, it's important that they get that psychological support, that mental health support, so that whatever are the risk factors that led them to be in the system, that they can be addressed through different methods. But because mental health interventions cannot be isolated, because there are so many social factors, so many environmental factors which are very dynamic in nature, they keep impacting their mental health and anybody's mental health and well-being. So really looking at how the psychosocial support can be an integrated approach that is not one person's job but a job of a system and multiple stakeholders in the system, I think then becomes important for the child to be rehabilitated, for us to really address what caused them to come into the conflict, and how do we repair that, and how do we ensure that there is rehabilitation and not just the system is not just retributive but fully rehabilitative. So I think that's why it's important. It's a very ongoing process. It's not a one-off thing that can happen, which I think a lot of people sometimes assume that with a couple of sessions or a couple of interventions or a one vocational course is going to really work, but it's really a long-term process that's really needed.
Absolutely, Kshipra, and that's my experience too, except in a couple of cases where it's a one-off incident kind of a thing. Many of the children do need ongoing rehabilitation. And I think for me, what I see it as the bottom line is this is the right of children in conflict with law. This is embedded in the object of the act. The children need to be rehabilitated and reintegrated. And if you look at it from a rights-based perspective, it is not like, some dole that the system has to give out. It is really what the child is entitled to. So let's talk a little bit more about trauma. You had mentioned about this trauma, and we see that children often have histories of trauma, neglect, abuse, and loss. And you would have definitely observed that many of these children develop coping mechanisms to deal with this trauma and adversity that they have faced in their life. So why is it important for juvenile justice boards and for lawyers particularly to understand trauma, even if they are not mental health professionals?
Yes. So like I said, a lot of our children have experienced trauma in some capacity or the other. And in our experience, it's not, again, an individual incident of experiencing trauma. It's a very complex, ongoing trauma that they have experienced. And like you said, as a result of that, a lot of the children's behavior, positive and negative, is influenced by that trauma as a result of that trauma. And this is, some of it is learned coping, some of it is a very subconscious coping that they have developed. So what we often see as behavior, and especially as negative behavior, problematic behavior, these are the words that we commonly hear, right? All of that is a result of trauma. And why it's important for us to look at that is when we are just focusing on the behavior, that's not enough, because you can't correct the behavior if you're not addressing the trauma behind that behavior. So it's very important for, and obviously as JJB and as lawyers, you're not expected to address that trauma. But what I think is really important is to have that trauma informed lens, is to have that understanding that the behavior that you're seeing, there is a very likely possibility that there was very complex trauma that led to that behavior. And I think that directs how we look at these children, how we treat these children. And I mean, treat as in the legal sense as well, but just also as humans who have been hurt. I think that humane treatment of children is really important. And that comes in when you look at the trauma that they have experienced. So I think that's why that understanding of trauma is very important.
Yeah. Thank you. I can hear a little bell going off, but I just want to underscore, Kshipra, and that is, yes, of course, lawyers and juvenile justice boards can play a huge role in addressing this trauma. And that is why arguing for interim orders, like, ensuring counseling is given, ensuring, a child is sent for detox when possible. These rehabilitative orders are a very important part of the law. So I do think there is a very important role that they can play. But let me just, before I move on to our next panelist, ask you, would you be able to share one message that you would like every lawyer representing children in conflict with law to take away about the significance of psychosocial support for children in conflict with law? What would that message be?
I think I said this quite a bit, but just listen to the stories of the children and not just the offenses. And let's not be bounded by the rule as the lawyer, but look at the spirit of the act more than the individual roles that all of us are playing. We are the adults in these children's lives, so we have to work accordingly. And I think in every step of the way, collaboration is possible. So if we collaborate, we can really bring in meaningful change in these children's lives.
Thank you, Kshipra. I think that's really, I think I'm underscoring the one main thing. Listen to the story of the child, the whole story, not just only the facts of the case and, what were the alleged offense, etc. And I'm also hearing you say that collaboration is possible. And I know that that's what you all do at Ashiyana. And we'll unravel this a little bit more as we converse with the other panelists. So thank you so much for your insights and your experience, rich experience with working with this group of children. I'm going to you now, Amaidhi. Let me just start straight off. What purpose do you think the social investigation report serves while preparing SIR for children in conflict with law? And how do you ensure that this report reflects a comprehensive picture, the story that Kshipra was talking about? How do you ensure that these SIRs represent that comprehensive picture, including their strengths, despite the adversities and traumas they may have faced?
Thank you, Arlene. Good evening, everyone. So yes, the SIR is a very critical document for a child in conflict with the law, and it has to be compulsorily done for every child. You will be surprised that in some JJBs, actually SIRs are not completed, but I think every lawyer and should push for an SIR, and the JJB should push for an SIR to be completed. As you and Kshipra rightly said, it gives a comprehensive picture of the child's background, their strengths, their weaknesses, and also their interests, and what they want to do. Using this information, the lawyer can advocate for a lot, like from starting from bail, because Section 12 of the JJ Act, a lot of JJBs now automatically ask for bail amount. So starting usually like from 3,000, it goes up to 10,000, and some of the JJPs even ask for surety papers. So with the SIR document, if the lawyer can advocate for waiving of the bail, if the child and the family cannot pay the bail, right? So from starting from the bail throughout the case, the lawyer can use, not just can, but must use the SIR document. It also comes in handy when the lawyer is making their arguments, because based on the circumstances of the child, the lawyer can advocate for counseling for the child and the family, and even for the final order. So that is why the SIR document is extremely important. And in our team, luckily, we have lawyers as well as social workers. So when we do an SIR, we look at it at both lenses. We look at it as the legal lens as well as the psychosocial lens. So what does the child need for their psychosocial support? And we also look at it at the lens as what will the JJB take away from this? How can we kind of push for counseling and rehabilitation of the child? So when our team is creating these SIRs, that's how we do it. We make sure that when we are asking or recommending something, that the child, also the rehabilitation is looked at, and not just for bail or PA processes. So that is how we have drafted our SIRs. Unfortunately, since we are a private funded project, we have an entire team creating these SIRs. We do home visits, which a lot of times is not done. We even go to the schools, we talk to the community. So to get a comprehensive document like an SIR, you need to do all this background work. Unfortunately, many times it's not done because the government actors don't have the same capacity as a private funded project. But since the SIR is such a critical document, I think even the JJB should push for like a comprehensive understanding of the child, and not just sitting with the child one time and writing an SIR, which often happens as we have seen. Yes, so to get a comprehensive understanding, you need the psychosocial as well as the legal lens, and you also need to anticipate how it will be read by the JJB and provide recommendations in that way.
Thanks, Amaidhi. I totally agree with you. Having myself had the privilege and the joy of working in leading a multidisciplinary team of advocates as well as counselors and social workers, I really wish that this model is represented, replicated in other places. I'd like to add, perhaps, I think in terms of the purpose, the law also envisages the social investigation report informing the individual care plans. So is there does your team also prepare individual care plans, and do you draw from your own SIRs, or do you see your SIRs being used to prepare individual care plans for children in conflict with law? Because these are supposed to be attached to the final orders. It's supposed to inform the final orders, as you said.
So unfortunately, we have not really prepared ICPs, because individual care plans, because that takes, like, the way the form is form is formatted. Basically, it takes over like a couple of months, right? Because you have a part A where you fill out all the needs of the child, and you have a part B which you do after 3 weeks, and then you have a part C which you do after a couple of months. Now, even as a privately funded project with all these resources, we found it very hard to do ICPs. ICPs are not done, at least in Karnataka, I can say for certain. When we have visited the observation homes and the JJPs, ICPs are not done in Karnataka. I'm not sure about the other states. We did attempt to do a few ICPs, just to kind of encourage the probation officer and the counselor to start doing ICPs. So we do a couple. We have done what is called the Juvenile Justice Board reports. So sometimes when the SIR is not sufficient, the JJB, they ask us, can you just find out a few more details about this child and submit a report, it is not part of the JJ Act, but this is something we have helped because the ICP is quite a long process. So wherever the JJP needs support in like finding out a little bit more of the child's background when the SIR is not sufficient, then we have completed those reports to help. We also never did SIRs for children we were representing, because that was a bit of a conflict. So we did SIRs for other children, but we also trained the staff on how to complete an SIR, at least to a certain level. We provided some level of training where we can get the SIRs and use them for our cases.
Thanks, Amaidhi. I'd like to just underline what you said in terms of conflict of interest, and maybe I'm going to pose that question to you, Geeta. Why is that a good decision to not work, to do the SIR and represent the child from your own team? But let me move on with you, Amaidhi. Do you think that CCLs, the children in conflict with law and their families, should be informed about what this social investigation report is and how the information will be used before they are interviewed for the SIR? And do you all do this?
Definitely, because a lot of the times the POs, the government POs, the probation officers have told us that the family refuses, when they call them if they want to do an SIR. That's because the PO is not explaining to them what the SIR is for. So the family is fearful. They think, the information will be used against them in the cases. So many times the family refuses. So usually how we approach it is we first introduce ourselves. We tell them why we are there. We tell them that this is what we're going to use and it's confidential, and this is just to understand the background of the child. And I think through the entire process, from the time you contact the family, go to the house, you have to constantly reassure them, because nobody has ever given them information about how the system works. So probably the only interaction they've had is with police, which might not have been a positive interaction. So they are very scared. So we have to tell them what the SIR entails. At least many of the families I've worked with, giving them a copy of an SIR doesn't help, because they will not understand what is there in it. So we are constantly with every question we ask, sometimes we explain why we are collecting this information and how we will be using it. So it is more helpful to kind of keep explaining the process to the family rather than just giving them a copy of the social investigation report.
Thanks, Amaidhi. I think even in our practice, every word that you write in that SIR, there are implications for it. So a lot of care needs to be taken on what is written, and it needs to be fed back to the families in terms of how this information will be used. And that's really the essential principle of justice in terms of fair proceedings and their access to the information that is being given to the Juvenile Justice Board about them. So time for a story from you, Amaidhi. Can you share an example where understanding a child's personal history significantly changed the way the case was understood or addressed? Yeah, and SIR that you submitted, how did that help in terms of the legal representation or even the interim or final orders that were passed?
Okay. So I had actually a story very similar to Kshipra's, of a child that kept coming into the system, and it was a similar outcome where we finally had to declare this child as a child in need of care and protection, and provide rehabilitation. And this is not just with one or two children; there are quite a few children like this that we've handled. So I'd like to give you a different kind of story. So basically, there was this boy who again from a single parent household, and he had joined the gangs when he was 12 years old, around 12 years old, and then he was accused of murder along with the adult co-accused. So he and the adult co-accused allegedly had murdered somebody from the rival gang. So what happened was, when the adult was released on bail, he was murdered outside the jail itself by the rival gang. He just got out of the jail and he was murdered right there in front of the jail. So when we were doing the SIR for this child, the mother herself pleaded, saying, please do not send him, because I am very scared for his life. I am very scared for my younger son's life. I want things to settle down. I want to change or shift houses before you can send him back here, because I'm scared. I'm worried about what the the rival gang will do. So using this SIR information and talking to, we had to do a couple of visits, because the boy was very adamant that he wanted to leave. He was I think studying that time, yeah, in 10th standard, just got drawn into this gang, and so he had a girlfriend that he could not live without, so he was adamant that he wanted to get out and used to beg us every day. But then it was a very difficult decision, but we had to make this recommendation because it was for his own safety. And as you know, Section 12 says if it is for the safety of the child, then bail can be denied. So then we had recommended that he stays in the observation home till things are sorted out and the mother can move houses. And based on that, bail was denied. And he was in the observation home for almost close to 3 months, because it was quite a difficult situation for the mother, and she was like, just keep him there, at least I know he's alive. And I still keep in touch with the boy, and he's fine. He's moved out of Bangalore and he's safe and he's working now, and his case is still going on. But based on the SIR, even though all of us always are trying to get the child bail, and even the JJP grants bail, this was one case where we actually had to say, please do not grant bail for this child. Yeah.
My goodness. Thank you for sharing this, Amaidhi. And I think while doing this, it's such a difficult decision, but I think from a rights-based approach, perhaps this was one way in which you all operationalized the best interest principle and felt that his safety was an overriding interest over, aside from his, right to education or, right to be with family or whatever. So a very challenging case. Thank you for that. I'm going to ask you, in terms of, while preparing the SIRs, how do you balance documenting risk factors and vulnerabilities when submitting these SIRs to the JJB? What are the, how do you balance those factors?
So I think, as we already discussed, the SIR is a very sensitive document. It has to be very intuitive. So for example, with the first cases that me and Kshipra we spoke about, where the child was a repeat offender, and then we can't just say, it's very easy to just say, declare this child as a CINCP and rehabilitate them. But is there organizations that are able to provide this rehabilitation? Is the CWC and the boys' home, the government boys' home, do they have the capacity to provide this kind of rehabilitation? So we can't just give we have to take all the factors into account. We can't just say, this child is a CINCP, declare him and send him to the government home, because that is not in the best interest of the child. Many times, even if the parents don't have the capacity to look after the child, sometimes in his best interest, it might be, we might have to send him back home. So the practitioner has to be extremely sensitive, intuitive, and well trained when they are making an SIR, and it can't just be ticking off boxes. And the SIR form itself, I find quite problematic because of the way a lot of questions are asked, like especially with the whole habits. It already looks as a child as a criminal, and the questions are very directed towards that, asking, okay, do you have drug habits, do you have alcohol habits, which first of all, I think many of those questions should not be in the form. But a practitioner needs to understand why they're in the form. They're not in the form to accuse the child or make the child feel guilty. They're in the form to ensure there's proper rehabilitation for the child. So similarly, there are questions, I think question 16, which asks, what is your relationship with your father or your mother? Now, if you ask a child, what is your relationship with your father and mother, the child will say, fine. Now, the counselor can't, the probation officer can't just say, fine, right? Why is this question there? The question is there to understand, what is the situation at home? Does the child have somebody that can support him or her? So I think practitioners need to be really aware of this, and they need to understand why this question is there, and what is the information we are trying to get out of this question, and how is the JJB going to interpret this? because we, again, it has to be child-centric and in the best interest of the child. So, like I was saying in the previous case where we had to say, many times we have not declared the child as a CNCP, even if the parents are not able to take care of them, because we know there are no facilities for this child. So it's better he goes home and figures himself out than put him in a in a boys' home, and he's going to run away from there anyway, right? So it is, and sometimes this takes multiple conversations, multiple house visits. So it has to be like a SIR is not like a one time you write it and you just give it, right? It has to be like an ongoing document, which I know is not practically possible, but I think we should strive towards that. So that's how in our team we try to balance it out. In our team we have the capacity to do it, so we can do it, but I'm also keeping in mind the capacity of government actors that actually do this on a larger scale.
Yes, Amaidhi, I agree with you. And I think what you were saying is also in terms of the information that you have, and also as a team trying to balance the application of the principle of presumption of innocence.
Yes,
there is something there that, information that you do have access to, but how do you prepare this SIR to tell this whole story of the child without, and writing these documents in such a way that you are applying this principle? Is there something that you'd like to share in just a couple of phrases, perhaps, and one message, Amaidhi, that you would like every lawyer representing children in conflict with law to take away with in terms of the significance of the SIR?
Okay. So just briefly about the presumption of innocence. In our experience, once we talk to the child, we gain their trust. They will tell you the entire case, what they did, what they didn't do, who did what, everything. So I think practitioners need to understand that this is not their job. They are not the lawyer, they are not the police, they are not the judge, they are not the executioner. Like, they are just there to fill in an SIR. So you fill in the SIR in the best interest of the child, and then you leave the job of judging and everything else, assuming innocence or guilt, to the judges, because that's their job, right? So I think many times when so that is what we need to remember while we are recording these things. So when a child says something, you say, okay, how is this, how can I use this in the best interest of the child? If it is not in the best interest of the child, I am not using it. If this is pointing to the guilt or the innocence of the child, this is not my job, I don't need to use this, right? So you let everybody do their jobs and you do your job, and I think that will create an effective SIR. And in terms of lawyers, I think most lawyers don't have access to the SIR. So I think, and they probably don't even know that they can get access to the SIR. So I think every lawyer should demand for, a copy of the SIR before they start applying for bail. And like I said, it's a standard 3,000 to 10,000 rupees bail amount. But using the SIR, they can actually say the child is from a low-income family, the parents are not working, and use section 12 and say the child cannot pay bail. Many times JJPs are asking for property papers. I mean, the backgrounds these children come from, they can't afford 2,000 rupees bail. Where will they afford like property and providing property papers? So I don't think lawyers know how important an SIR is and how that can be used in the entire process of the case. So I think lawyers need to also be trained and understand how an SIR can be used. And just to wrap up, Center for Child and the Law, NLSIU, we have released a manual on, training probation officers and counselors on how to do an SIR, which Geeta was also part of, and a large contributor, and Arlene, you as well. So it is there online. We've also released a tool book of just do's and don'ts, because we are a lot of, in Bangalore at least, a lot of students come to do SIRs, and they've just said, here, do an SIR. So we also have like a tool book, which is at least like a basic checklist of what to look at, and when you're filling an SIR. So these resources are available online for anybody who wants them.
Thank you so much, Amaidhi. That was very informative. And yes, thank you for remembering to share about these resources. I'd like to add to that Enfold has developed 5 videos on social investigation reports, including one on best interest principle and SIR. These are customized for the use by for preparation of SIRs for children in need of care and protection, but it's very useful in terms of understanding what an SIR is. and can be applied also for preparing these documents for children in conflict with law. But your last point in terms of, this leads me very as a segue to a conversation with Geeta. And in terms of, as a lawyer, to use information in the SIR, and would you argue for bail or not argue for bail? This is a big one for you coming your way, Geeta. What is your role as an advocate for children in conflict with law? And maybe do you want to start with that question, Geeta? Somebody who's an advocate, a practicing advocate, and somebody who has almost 2 terms as a Juvenile Justice Board member. This professional role of advocates to advocate for bail. Every child has the right to bail, and there's a unique provision in the JJ Act. So how do you share, balance this dilemma of, should you advocate for bail or should you not advocate for bail because a child needs protection? So Geeta, that one's coming your way. You're on mute, Geeta.
Thank you, Arlene. That's a very complex area of conflicting interest. Like the child asks the lawyer, "You please get me out on bail." There are conditions which in the SIR says that it's harmful if he goes out. Like we had a case wherein the child was harming himself when he was within the observation home, and there was an SIR which indicates that he's actually getting into harmful activities. So therefore, he requires supervised conditions where he is kept inside and he cannot be let out because he had only a single parent, that was mother, and she used to go out for working. So therefore, if he was let out outside on bail, he would harm himself. But as a lawyer, I was supposed to listen to my client. I can't say, no, it is not a good option for you. Though I can explain him why we don't want to press the bail, but that is like not listening to the client's wishes. And in fact, we filed the bail application just for the purpose of his satisfaction. We filed the bail application, which ultimately got rejected because JJB understood that if we send him outside and mother is not in a position to look after him while she's not there at home, so we may actually be risking the child's life. So they denied the bail for him. But the child was very upset. He took away the brief from us. He appointed another lawyer and then he got out on bail, and we did not hear thereafter about his well-being. So that is a very, very tight, it's a very catchy position. So we really can't take one-side decision, and best interest has to be decided by the JJB, and lawyer has to act as per the direction, as per the wishes of the child and the family. Here also there are cases wherein family doesn't want the child back. They insist the child to be kept inside the observation home because they are not in a position to take care of the child, but the child doesn't want to stay inside. So when these kind of conflicting interests are there, even for the JJB, it's very difficult position, but many a times judges want to see that their staff is happy. They don't want to burden the staff with a troublesome child. So they see to that every child is given bail and sent out. They don't want any troublemaking children. But JJ Act is for these children, and we need to develop our system. We need to have trained staff who can handle these kind of situations as well as children. So I think there's a lot of things that need to be changed in the system. Yeah, but the lawyer has to take a call, and he has to act as per the wishes of the child, and he cannot go against the wishes of the child. And JJB has to act cautiously while taking the application as well as looking into SR and then come to a conclusion.
Thank you, Geeta. I share your, this conflict, and I think maybe we could discuss this a little bit more with perhaps during our open house. Thank you for sharing your the challenges that you have faced and the principles that you have abided by while practicing your legal profession.
I also just wanted to add one more thing is
Sure.
that when I joined Center for Child and the Law, the everyone is discussing about one case. We had a team of Arlene was there as a social worker. We had a child counselor. We had one more legal expert with us. Swagata was also there, and we also discussed the case with Nimans. My entire problem when I entered Center for Child and the Law was that why is everyone discussing this issue? It is mainly the offense. The child has come into the system only because he has done an offense, and the offense is important. And my whole perspective has changed after having worked so many years under JJ Act, that it is not at all the offense. And I was really on a wrong position of focusing on what is the offense, why he is come. But we have to look into what are the factors, what made him come into this system. That is where we all the stakeholders have to look into and work towards that.
Thank you, Geeta. Bringing back memories of the long debates and discussions that we had as a team. And yes, and how we tried to keep focused on the story of this child and really what is in this child's best interest. So thank you for sharing the evolution of your learning and understanding of children in conflict with law. Absolutely precious for young budding lawyers. So tell us, maybe in more clear terms, what should lawyers understand and respond to? Why should they respond to the psychosocial needs of children in conflict with law? And how can they do so as part of child-centered and trauma-informed legal representation? Is there such
Yeah.
a thing, trauma-informed legal representation?
Yes, actually, this question I would like to answer it in through my own example that we had handled in Bangalore. There was this child called Mani. He had come with he was extremely violent in the observation home. He was charged with an offense of murder of his own father, and he was brought from rural Bangalore to Bangalore, and he was put in there. He had no family. His mother was put in jail for the same offense, and his father was killed. And his grandmother was there, who was not, who really couldn't come to Bangalore to meet him. And he had violent episodes at observation home. JJB wanted to get him out of the system at the earliest. And this is when uh, we really had to take a call. Each of the stakeholders, like the social worker, even the probation officer, we had called for a meeting of all the people so that we can take a decision. And there was a charge sheet also that was filed in the case, and there was no witness. There was no witness of him killing his father. It was in some remote forest area that offense had happened. There was no eyewitness, nor there was any circumstantial evidence to prove his guilt. But the child from day one had kept saying, I have done it. I have done it. I've killed my father. And he had quoted all the sequence of events that had happened. And never he gave us any kind of doubtful version. He always stood by his version. And when the child was sent for psychiatric assessment because he was having lot of violent episodes, he was hitting other children, he was shouting and yelling at the staff. When he was produced before the JJB also, he was telling the JJB judge, listen to me, you have a duty to listen to me. I'm a child, you should listen to me, and you please send me out of this system. I want to go outside. And when the judge saw this kind of his version, he was like, he needs to be sent to Nimans. Please take him. He needs psychiatric treatment. And when we went and met the doctors treating him, they were of the version that he is the one who's accepting his guilt. So therefore, when the charge sheet has come and he wants to accept his guilt, you have to explain him what are the consequences of accepting the guilt and what would lead him into. And thereafter, if he's willing to take on and still abide by what his story is, then we should allow him. Unless that happens, he's not going to be healed inside, and he will continue to have this post-traumatic stress disorder. So therefore, when the doctors also said that the healing part would happen when he accepts his guilt in front of the JJB. So that healing process would take time, and this is how it should be. Then we actually went and met the law professors in the National Law School University. Everyone told us, don't ask him to admit guilt when there is no witness. Why do you want to push the child into this? And in fact, the JJB judge was also refusing. He said, you are forcing the child to admit guilt. We said, we are not forcing. It is his own version. He wants to admit guilt. And we had to even convince the judge that if he wants to admit it, please record that. And also we made a 313 statement to be recorded. And here most of the lawyers don't give attention to 313 statement. 313 statement is usually prepared by the JJB and put into the child and asked whether do you agree by all the statements of the witnesses. And most of them would say, no, I deny. And many lawyers don't even attend this proceeding of the recording of 313 statement. This 313 statement, in fact, we drafted it and gave it to the JJB and said that this is for the healing process, and the child understands what he is getting into. We have explained him, and he's ready to abide by this, and it is his own version. It is not that we are pushing the child to admit his guilt. So there, after 3 to 4 times of arguments with the JJB, the JJB said, okay, fine, I'm going to record this. And since the SIR is also there, and then we also got the PO to prepare an individual care plan. The child was very intelligent. He was really very good at his studies. He wanted to do chartered accountancy. So we saw to that he stayed in observation for 1 year, and then he was given 1 more year in special home, and after that he was admitted into a college. And all this took a lot of efforts of a team of 5 people with probation officers from the OH, with Nimhan's team, and with all of us. And for one child's rehabilitation, it really required efforts for 6 to 7 months, and there was frequent meetings. We had frequent multidisciplinary case conferencing, and we called many members to attend this. We in fact tried to get even the grandmother, but she couldn't come. We made a visit to the child's place in Andhra Pradesh. We took the probation officer to Andhra Pradesh. We went and met the school teachers. We went and met the neighbors. So all of this definitely required a humongous, huge amount of efforts. And this, I don't think, like what Amaidhi said, whether the government machinery has got this kind of support system to invest time, energy, money into each of the child that requires rehabilitation. And this is where, if I was not with CCL, I was not with Center for Child and the Law, maybe I would have just said, pleaded not guilty, and also made the witnesses record their evidence, and then the child would have been left out without any direct evidence or circumstantial evidence being there, and the child would have come back again with many more cases. So this is the change that I saw when we actually dealt with SIR. We actually dealt with having all the stakeholders sitting together, working together towards rehabilitation of a child, and wherein the child admitted guilt. And we were not like the traditional lawyer saying that, please don't admit guilt, we'll say not guilty, and then we'll go on with the case.
Thank you, Geeta. Though I think you did mention a pseudonym, and I think this child is actually no more, and I don't want to mention his name either, but in memory of him, just as a message, what is the message that you would like to give to advocates representing children in conflict with law, perhaps from all your experience and your learnings? And this question about should lawyers actually ask for copies of SIRs, what are your views on that? And what is one message you would give to lawyers? Because we now need to go into an open house. So we would conclude with what is your message? Yeah.
Yes, they have to seek for, because the child has got a right for fair hearing. So therefore, every lawyer needs to apply for certified copy of the social investigation report. Even the child victim has a right to seek the social investigation report. Even they can seek it, and that should be given because both parties have got stakes in the matter. So therefore, they should be given copies of that. Use that for rehabilitation of the child. Use that for, see if you can get avoiding transfer of the child's case. If the child is below above 16 years and is alleged of heinous offense, use the circumstances that have been mentioned in the SIR. If he comes from a poor family, he has peer influence, and he is addicted to any of the intoxicants, then make use of them, argue it for the rehabilitation of your of the child, and try to prevent, if at all the child is going towards transfer system, get it avoided and make the best use of the SIR, and also use it for further rehabilitation. Ensure that there is an individual care plan passed, because none of the cases have an individual care plan. You make a advocate should actually seek for individual care plan, and even irrespective of whether he has been found guilty, not guilty, getting individual care plan is very important, because once the child has come into the system, there has to be some kind of rehabilitation that is required. If the child requires, then that needs to be done. He cannot be just sent off saying that guilt is not proved and the offense is not proved, therefore he doesn't require any services. That's a very wrong interpretation. Then we are just dealing the matters like how we deal in court with the adults cases. We are similarly handling those matters. So that is the difference. When we use SIR, we can make a difference to the child's life.
Thank you so much, Geeta. I think some very complex issues, and I think we may need some further discussion on some of these. This conflict of interest issue, this issue of when the child wants to plead guilty, and for their own healing of their trauma, and you as an advocate, so those kinds of challenges, quite complex questions. Also, this question that you just now mentioned, or this point that you mentioned, that ICP should be made for children, whether they are found guilty or not. I'm just wondering a little bit about that in terms of, does that then pull the children back into the system, which is in our experience, it's not really child-centered, child-friendly, or should it be only in cases where a child needs to be referred for care and protection, even if the child is found, not guilty, or even during the process of the hearing where the child needs to be treated as a CNCP. So I still have some questions. But thank you so much for sharing your personal journey, the evolution of you as a young lawyer and now as an accomplished JJB member, going back to lawyering children. Wonderful, Geeta. Thank you so much. And could you point us to some questions that may have come up, and we can now have an open house?
Yes. There's one question about the ICP is mandatory for the dispositional order, but how many JBs are actually attaching it, which is coming from the last comment from Geeta.
Okay, so Geeta, would you like to answer that?
Actually, none of the cases, even if the child is found guilty, they are not preparing the individual care plan. Because the judges think that once an individual care plan is prepared, and there is a phase where they have to monitor and report it back. So they think that cases would be pending, considered as pending. So therefore, they don't want any kind of pendency. So therefore, they don't want ICP. So therefore, here in Karnataka, at least in Gulbarga, not even in one single case, an individual care plan has been prepared.
Yeah, there has been some that have been prepared, but not too many. But anyway, I think a similar question has been asked by Navneet Kumar. It is mandatory for dispositional order, but how many JJBs are attaching with it? So I think this seems to be at least a nice.
That was, and then there's one from Ranjana adding to that. On an average in CICL and end-to-end process, how many ICPs are developed, and on an average for CICLs and an end-to-end process adopted, and how many principal magistrates are sensitized on ICP relevance?
Yeah, I think maybe anyone can answer. I think we all know the answer to this. How many are actually sensitized and what is going on in reality? I can see you nodding, Kshipra. Is this the situation in Maharashtra? I think we're all working with the system, and we know that there are some excellent, members and functionaries and stakeholders and JGB members in our experience. But largely, there's so much to be done to strengthen the system. So,
Yeah.
is that I see you nodding, Kshipra?
Yes, I think that's absolutely true. But what we've also seen is that a lot of non-profits are advocating for this. So we've also had other non-profits prepare ICPs and submit them to the juvenile justice boards and ensuring that they are actually attached as well. So I think what you're seeing is that if the system and government officials are not ensuring this, then there are NGOs who are taking it up, but still the numbers are nowhere where they have to be ideally.
Yeah. Thank you, Kshipra. There's a question on, please tell us your experience with Section 83 inquiries for children under 12 and the relevance of SIR for the same. Geeta, would you be able to take that? This is a question from Pranita.
Sorry, could you repeat that?
Please tell us your experience with Section 83 inquiries for children under 12 and the relevance of SIR for the same. I think this is the ICPS provision that has been quoted. I mean, not ICPS, IPC, sorry. Yeah, in my IPC provision. So basically for children under 12, and is there a relevance for SIR under that? Yeah.
Yeah, actually, SIR is relevant for all the children who come into the system. But even for children under 12 as well, we had case who was there was a group of between 10 to 15 years. They were a group of friends who saw porn on the net, and they got a child from their neighborhood and raped the child. So they were before our JJB, and we had ordered for SR, though I had mentioned our judge that we should not go on with the inquiry, saying since they are below 12 years, so we can actually see to that they are given counseling services and sent out of the system. But the judge was very insisting, saying that when they have come into the system, let them face the consequences. We cannot let them off from here itself, because they'll consider this as one more chance for them to get in back into the system. So she was adamant that the child goes through the inquiry procedure. So we went on with the entire inquiry, and then they were let off.
Did the SIR play any role in whatever, how the JJB responded? Was an SIR prepared? And I think that's the question.
Yeah, the SR was prepared for them as well, and the SR indicated that the child should be sent to a school or a hostel wherein he is kept away from the neighborhood. But I don't think the parents were not in a position to shift them to other places. So none of the recommendations of the SR were put into action by the JJB.
I also have a similar case. Can I add, Arlene?
Yeah, very briefly, but in the meanwhile, I just also want to request the audience, are there any specific questions related to child rights lawyering from these sharing of the panelists' experience? We're really trying to get budding lawyers more engaged with the psychosocial aspect of the law and what that means for them. So just asking those who are in the audience and also experienced practitioners. We have some Marukus on the call. Please feel free to add your perspective and experiences. This is really an important and a complex discussion. So would love to hear from you too. So go ahead, Amaidhi.
Yeah, just very briefly. So there was a boy who was 11 years old, and he, in a childish fit of anger, he pushed another boy. They were fighting over a T-shirt, and the other boy fell and hit his head, and the other boy passed away. So there was a murder case put on this boy, murder due to negligence. There was a case put on this boy. He was 11 years old. So we went and approached the JJP, and he said, the SI again, his did not have a father. Mother was like a rag picker. So we asked the judge to dismiss the case, just provide the child with counseling, because he was also very traumatized with what happened. But because it was a heinous case, the JJP said, no, it's a heinous case. We have to, go through the due process. So I think the magistrates, members, they really need to be sensitized and trained, because this is actually a section in the JJ Act and in IPC, but but they didn't even want to take that up. So that was one case, and we are still representing that child in that case. It's been 3 years. So yeah, just wanted to add.
So yes, there is so much more focus now on the offense rather than the whole story. And that is really the whole problem with the system. And despite what the preamble of the law says, there are some other questions, I think, from Sunaini.
There's one hand up.
Okay, there's a hand up, but I'll come to that. There's a question from Sunaini Livingstone, and she asks, regarding the use of ICP, is there adequate follow-up and effective reference points to measure the improvement, keeping in mind the specific goals and the general goal of best interests of the child? So which of you would like to take that? Any of you?
I mean, my answer is very, very short. No. There is no follow-up. We did conduct a few ICPs, but we could only do part A of it. We could not get contact information of those children because of the confidentiality, and we were not representing those children. So we did part A. We submitted it to the counselor. I don't think there has been any follow-up or anything done.
Geeta, what is your response? That's similar, I think.
No, actually, in Mani's case, we were able to get the ICP followed through up because there was an NGO involved. I think this was done. And the judge also got to know that he won't be left if he doesn't follow up with the ICP. So I think the JJP members as well as the judge cooperated, and we were able to get the follow-up done in Mani's case.
Yeah, of course, we were not an NGO. We were Center for Child and the Law, but we were non-government. So in that sense, yes, we were non-government. But I must say, and from my own experience, that follow-up for children in conflict with law and also for some children in need of care and protection takes years. It's not just 3 months, 4 months. There's so much underlying root structural causes that have driven children and their families into, poverty, and they're being criminalized for it. So yes, this follow-up, beyond what the JJBs demand, genuine accompaniment of these children in their rehabilitation and reintegration takes years. So that is really something, unless we bring in more fit persons, bringing in more social workers as provided for under the rules in Rule 2118, a community of people who care for these children, who can walk with them. And I think that's a dream. Another dream I have is really a cadre of child rights advocates and cadre building, because like even in a case that is currently being we are handling, is that there are advocates who are representing them before the board. But when it comes to their civil rights or other rights, it requires, again, access to other, free legal aid lawyers. So in terms of follow-up and ensuring their needs and their access to entitlements and protections under the law, it requires so much of follow-up. So that's really, I think, clear from all of us.
Should we take Selvi's question first, and then we'll end with Rakesh's question?
Please, yeah. Selvi?
Oh, thank you. Thank you so much. Thank you. It is so nice to hear from you all, and I really learned a lot. This issue is very, very close to my heart. I just want to introduce two persons who worked their entire life on this issue. There is one Catholic nun. She is a lawyer. Her 35, 40 years of life, she worked in UP, and she took children one by one out from juvenile homes, and she kept in a home, and she educated all of them, not one, not two, hundreds, not 100, not 200, several hundreds of children. She educated them, and now they are all doctors, nurses, MBAs, engineers, and all that. Okay, so that's her commitment that she did. There's another person I came across. His name is Cyril Prabhu in US. He's from India. He was in US all his life. He worked and he helped close 5 prisons in across US. Right. So he had come over here and he wanted to work for juvenile justice, and he was not getting any breakthrough. So just I want to connect them with you all. I know I've been holding several talks and sessions with such kind of people, connecting with people who are working on, because it's a larger issue. When we come together, there will be synergy. When we can work together, we can pull in resources, knowledge, and expertise, and help these children. I'm a lawyer. Okay, I go for other cases to court. I see these children are being taken, they are given remand and they are taken to children, homes, and I'm like, my heart breaks for them, right? So that is how I just got involved in this whole process, and I'm just trying to connect all those who are working in this field, and I would like to connect with you all. So I'll send an email reply to the where I got this thing. Okay, thank you so much.
Selvi. Thank you, Selvi, for sharing that there are some wonderful people who continue to do this work and over years, as you said. So we're really happy to connect with them. There are more questions here, and I think there's somebody from Nivea. Nivea, who's asked a question.
So I think we can combine Rakesh and Bipasha's question. How do we avoid stigmatizing the child and family while conducting the SIR? And Rakesh's question was, the whole system is focusing on the offense and not on the psychosocial story. How to deal with it?
So can I just refine the question, or maybe fine tune it is in terms of lawyering, because I really am, again, our major audience is really our budding lawyers and trying to build this cadre of child-centered child rights lawyers. So Geeta, would you be able to respond to that? And speak to lawyers, yeah.
Sorry, can you repeat that? There are too many questions on this one.
Yeah, Anne, could you just read those 2 questions? But Geeta, to respond perhaps while speaking to lawyers, if you can. Yeah.
Yeah. How do we avoid stigmatizing the child and family while conducting the SIR? And Rakesh's question is, the whole system is focusing on the offense and not the psychosocial story. How to deal with it?
Yeah, while conducting SIR, actually, we try and see that whichever community the child is coming from, not to go there like a journalist seeking information and all, to try and see that you dress appropriately and don't take your notebook and pen and sit and write their answers in front of them. Let it flow as a conversation. You can, with the consent of the family, if you think details are missed out, you can record the conversation. However, that needs to be done with the consent of the family, and let it be like a person coming and meeting them. It shouldn't occur to others that they have come to do an inquiry and get more information about the child. So the PO also needs to be sensitized enough, and I think they are also given training how to conduct the SIRs when they go and meet the families. But most of the POs don't go and visit the families. They collect the data from the child when the child is at observation home. So the family visit is hardly done. They are also hard pressed for time. They also do many of the social investigation report for CNCP children. So they are hard pressed for time. So they don't go and visit. They collect the data from the child and they put it in. So therefore, the SIRs are mostly sketchy. They don't provide deep information about the child. And psychosocial story that you can get through once you get a copy of the SR. You have to, as an advocate, you should ensure that the SR is given in time. Whenever a child is produced before the JJB, that time itself, the police is supposed to give information to the PO, and PO need not wait for a direction from the JJB to give the SR. So you have to ensure, when you know that your client has been produced before the JJB, you should ensure that the information has reached PO, and PO is working on the SR, so that by the time you file a bail application, SR is also available with the JJB. Although JJB is not bound to take the SR before passing a bail order. However, in heinous offense, it is in the interest of the child that SR is looked into before the child is released on bail.
Thank you for that, Geeta. Enfold is going to spend more time and perhaps another webinar on SIRs and preliminary assessment, especially in heinous cases. So thank you for just referring to that there. I also want to say that, if I may, lawyers should not just only ask for the SIR. I think spending time with your client and trying to understand your client and the client's family yourself is equally part of your job. So I see Maruk stepping in. Yes, Maruk.
No, I just want to say one thing to the lawyers is that you are not going to get a perfect SIR. Okay, there are going to be things in the SIR, so it's not enough just to read the SIR. As lawyers, we need to sit with the SIR and really think about it and see how we can use each factor in the best interest of our child. Like very often there is a assumption that, okay, if the child is, what should we say, substance abuse, then we can use that as an excuse, with regards to like diminished responsibility. But many children aren't. Then we have to think of another response as to saying that this child doesn't have any risk factor. So the rehabilitation of that child is going to be easier. So what I'm just trying to say, we also, before going into court, it's not just reading out the SIR. We have to sit and think as to how we are going to use everything which is stated in the SIR in the best interest of the child. That's all I want to say, is that as lawyers, we spend so much time reading the IPC and reading the offense and seeing how should we deal with the charge sheet. But even the SIR we should spend as much time with, because we have to sit, I don't know, I won't say the word assess, but we have to speak about how this factor is in favor of the child. Like sometimes, as we know, SIRs, of course, we say it's incriminating. You shouldn't rely on it. But sometimes I say the child is honest. The child is not manipulative. So, the child can be rehabilitated, because everything we read in the SIR, the ultimate thing is to show that the child can be rehabilitated. I'm also talking within the juvenile justice system, because nowadays we are using it a lot in doing preliminary assessment too. So I'm just saying there are going to be people who are going to be preparing SIRs. Very often it may just be the probation officer, but we have to also spend time with it to be able to explain it so that it serves the best interest of the child. So please read the SIR very closely and keep reading it and think of ways as to how you are going to use some of the negative aspects in favor of the child. Thank you.
Thank you so much, Maruk. Absolutely resonate with you there. And also wanting to say that, child rights legal representation, when one has the support of counselors and social workers and trying to collaborate with one another to try and assess what is this child needs and what would a best interest determination look like by the JJB, I think that is where this multidisciplinary approach, this child-centered approach, trauma-informed approach comes alive. So how can we do that? And perhaps I'm even wondering whether advocates can look at the horrible quality of SIRs and even ask the JGB and say, this is really no, I request that another SIR be done for my client, to even push the system to demand this kind of quality-based work. So I think there are more questions, some of which we're not able to answer. Somebody has asked about, Prardhana Sunil has asked about foster care for children in conflict with law. When I was working in Mumbai in an organization called Sneha Sadan, this was way back 1990 to 1993, Sneha Sadan had group foster care homes for children, and children were being picked up from street situations, many of them who were into a petty crime. And some of them, I mean, I don't know enough. I was a young social worker then. And these children were kept in group foster care families, and nobody knew the difference between any of them. Because some of them happened to get caught and other them apprehended by the police and others were not. But this family-based approach, this community-based approach, where people, counselors, social workers worked with these kids just like they were any other kids, and supported them, accompanied them, and perhaps even challenged them to consider changing their behaviors when their needs were being met. They were provided care and shelter and counseling. That is what this Juvenile Law Justice Act is meant to achieve. So really, I think our time is up, and I hate to conclude because I personally would have liked to discuss this so much more with all the complexities in it. But maybe I will conclude here. And the bottom line being is like, what is it that we can do to strengthen this system, to ensure that a child is never, ever defined solely by the crimes they have allegedly committed, and where we can really work together to try and help this children who have committed these crimes to move towards accountability, but through a restorative approach, through an approach that recognizes their humanity, their survival, the structural root causes of why they've got into these situations, and work with them so that they can move forward in a good way, with hope and with dignity. So I do hope that our young lawyers on this webinar today, and those who are already practicing in the system, that come together as a cadre of advocates who think differently from the regular lawyers who are, many are working in the criminal justice system and the juvenile justice system, and very difficult to transition from one court to a juvenile justice child-friendly court. But still, when we can have these conversations, support one another and challenge one another, and draw inspiration from each other, and the stories that we've heard today from our wonderful panelists, perhaps we can continue this journey and be part of the change that we all want to see through the lives that we impact, and the decisions, the best interest decisions that we argue for by the Juvenile Justice Board. So I'd like to thank our audience today, for all of you who have made time to join, but very specifically for each one of you, Kshipra, Amaidhi, and Geeta. Thank you so much for not only what you have shared today, but for all the effort and the care and the sweat that you put into this work. I know it's not easy, but I think all of us also experience the joy when we see those little changes and we see those children see the law come alive for them, where they're getting access to Section 18 rehabilitative orders, they're getting support, they're getting sponsorship. How many sponsorship orders are being advocated for? So I just like to push that in there, that very often this is not being claimed for these children, and they are very much children in need of care and protection. And together we need to be able to, I'm going to use Kshipra's words again, not only listen to the whole story, but really ensure that we try and respond holistically to the needs of children from a rights-based approach. So thank you everyone for this wonderful conversation, and hope this gives more food for thought for how we can change not only the way we think about these issues, but how we relate to these children, and how we can perhaps make a concrete change in the justice system. Thank you. Good evening. Have a good day.